Breaking news out of the United States District Court for the District of Illinois, specifically the Southern District of Illinois. A federal judge has denied a motion for a preliminary injunction, basically declaring that his hands are tied by virtue of the terrible Second Amendment decision by the bitter Judge Frank Easterbrook and Diane Woods there in the Seventh Circuit Court of Appeals that rejected all Second Amendment claims against the Illinois quote-unquote assault weapon ban. Let's break down what Judge McGlynn said. He said some positive things and interesting things. We'll talk all about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee for two separate categories for the 2024 Gundy Awards, one for Top Male Influencer and one for Top Voices of the Second Amendment. I am proud of both nominations. All right, folks, so as you know, Illinois enacted a quote-unquote assault weapon ban, which is just a ban on semi-automatic firearms and magazines that hold more than 10 rounds. They also required that you register those firearms and parts by January 1st, I believe this is the deadline. I'm sure you know the laws better than I do out there in Illinois if you live there. Bottom line is the registration date is obviously upcoming. So in light of the terrible decisions by the United States Court of Appeals for the Seventh Circuit out of Chicago with Judge Frank Easterbrook and Judge Diane Wood, both stepping up and saying that the Illinois assault weapon ban was perfectly constitutional under the Second Amendment, misapplying all of the laws involving the Second Amendment. We've covered this before in a 2-1 decision over a dissent by Judge Brennan. And no intervention by the U.S. Supreme Court, likely because they view this case as an interlocutory case, meaning it's in the middle of the case and they don't want to get involved until the case is over with a final judgment, and there is no final judgment. Unfortunately, where we are now is there was a series of motions just made in a last-ditch attempt to try to shut down the Illinois registration requirement. Apparently the way it works is if you have these alleged prohibited items, firearms and parts and whatnot, you have to register them. If you register them with the state of Illinois, you no longer have, you can possess them, but now you're on a registration list, which is probably also unconstitutional. Nevertheless, Judge McGlynn was asked to enjoin this state law and prevent the registration from taking effect. The plaintiffs essentially argued there's a couple different reasons for this. One is that the law was not well known and there's not proper notice given to gun owners, and that was a violation of the Due Process Clause. There's also an argument that the law is vague as to what it applies to and what it doesn't apply to. And a related note, they also re-argued aspects of the Second Amendment claim, the right of the people to keep and bear arms, and this registration would violate that. So Judge McGlynn, basically in a long opinion, about 34 pages long, I'll put a link to it down below, denied the motion for a preliminary injunction. But he did so on some very specific grounds, and he clearly expressed his dissatisfaction with the Court of Appeals for the Seventh Circuit. But again, since he is a United States District Court judge, a trial judge, he is bound by the decisions not just of the United States Supreme Court, but also by another superior court from the perspective of Judge McGlynn in the U.S. District Court for the Southern District of Illinois, and that is the decisions by the superior court known as the U.S. Court of Appeals for the Seventh Circuit out of Chicago, which is the Court of Appeals that oversees his work. So it is with that context in mind that he talked about the four related cases in front of him. That's the Barnett, the Harrell, the Langley, and the Federal Firearms Licensees of Illinois case. They're all kind of consolidated together. And he basically assessed this and denied the motion for a preliminary injunction. First of all, when it came to the vagueness argument, he says it's crystal clear. There's nothing vague about what's going on here. He says the law is clear that what it does prohibit and what it does require. He says, of course, it doesn't mean it's constitutional, but in terms of the way it's written, he thought it was at least clear. So specifically, he makes clear it's not vague. This is what he writes on page 29. He says, quote, "Thus, the emergency rules implementing the PICA registration requirement," that's the Illinois law registration requirement, "are not unconstitutionally vague. Rather, they are clear in what they prohibit, serious issues with the Second Amendment aside." So again, here you have Judge McGlynn raising questions as to whether or not these laws are constitutional under the Second Amendment, but as to what they require and don't require, he says they're not vague, they're clear, crystal clear, albeit maybe unconstitutional. On the second ground, again, these are really due process arguments. The vagueness argument saying that the law is vague and unclear is a due process argument, that there's not sufficient due process because you don't know what the law is, so you can't comply with it. He rejected that on the grounds that it's not vague, as I just illustrated. But then he goes on to talk about whether or not whether or not it was clear to people as to what they're supposed to do. This is what he writes. He says, specifically in regard to the registration requirement, Illinois has taken various actions to notify Illinois citizens of the requirements under PICA, I think that's how it's pronounced, and the emergency rules. Thus, this court, that's Judge McGlynn, finds that the FFL plaintiffs have not established a reasonable likelihood of success on the merits of their notice claim, even if they did have standing to bring it in the first place. So there's issues about standing we don't need to get into for the purposes of this video. It's not relevant realistically for the moment. The bottom line is, he goes on to say, although this alone is fatal to the claim regarding irreparable harm, the individual failure to register his or her firearms, this is quite interesting. Judge McGlynn is flagging a potential defense as I see it here. Let me just read it to you carefully. You'll see what I'm saying. He says, quote, the individual failure to register his or her firearms, attachments, and ammunition by the January 1st, 2024 date does not by itself cause criminal penalties to automatically attach an issue. Rather, the government must prove that the individual in question, quote unquote, knowingly possesses the item in question. Therefore, the court finds that the FFL plaintiffs who made this motion did not meet their burden in the threshold phase to proceed to the balancing phase of their notice claim, meaning do the people have sufficient notice about what they are supposed to do and can't do and so on. And that is what the judge said. So there was really a due process argument here that there wasn't sufficient notice given to Illinois gun owners. And the second argument was really a vagueness argument saying that the law is vague and unclear. And Judge McGlynn rejected both of them. So with those procedural issues rejected, Judge McGlynn then goes on and has a section on the Second Amendment. Specifically, he says that the FFL plaintiffs seek a preliminary injunction to bar enforcement of Illinois' registration scheme as it violates the Second Amendment. He goes on to say, because the Seventh Circuit has not yet issued its mandate at the time of the filing of their motion for a preliminary injunction, the plaintiffs focused their argument in firearms parts and attachment as these were not explicitly discussed by the Bevis case up above. But the bottom line is that Judge McGlynn, his hands are tied. It's pretty clear he views that these laws to be entirely unconstitutional, which is why he enjoined them in the first place. But then his preliminary injunction in favor of American and Illinois gun owners was simply thrown into the trash heap by the U.S. Court of Appeals for the Seventh Circuit, by those terrible anti-gun judges who are intellectual giants in their own mind. Judge Easterbrook and Judge Wood both want to be on the Supreme Court, did not get on the Supreme Court, and are very bitter about it, in my opinion. And that's why you get these opinions that, to me, just reek of thumbing their nose at the U.S. Supreme Court, not to mix metaphors there. But let me carry on to say specifically, Judge McGlynn points out in his opinion that the Seventh Circuit clearly indicated that the Second Amendment challenges to gun regulations often require more evidence than is presented than in early phases of litigation. Now, this is clearly wrong, of course, because we know the amount of evidence and expert testimony, and any kind of testimony for that matter, that was heard in the Heller case before the Supreme Court, in the Bruin case before the Supreme Court, in the Caetano case before the Supreme Court, in the McDonald case before the Supreme Court. There was no trial, there was no testimony, there were no experts. So the only types of people that say that you need a lot of discovery and experts and so on to litigate Second Amendment cases in this country is the anti-gun lobby that wants to bankrupt the Second Amendment movement in all respects, and they want to drag their feet as long as possible with as much discovery and experts and testimony, whatever they can do to prevent any Second Amendment case from getting to the U.S. Supreme Court. But the reality is, again, here's Judge Stephen McGlynn, quoting the Seventh Circuit. I think he quotes the Seventh Circuit on that point that there's more evidence that may be required to illustrate the point that he disagrees with that. It's just simply not true. But again, the Seventh Circuit Court of Appeals is effectively his boss on these things, and he's bound by those decisions, even if they're dumb and just full of bitterness and thumbing their nose at the U.S. Supreme Court. But I'll get to what Judge McGlynn says about this in 1 second, because he seems to indicate he's not going to follow the Seventh Circuit to the extent he thinks the Supreme Court law is inconsistent. We'll talk about that in just 30 seconds. But the next thing he goes on to point out that, and this is very interesting, I think what Judge McGlynn has understood is that the anti-gun movement in America wants to drag their feet, because this is what he says. This is telling. On page 33 of his decision, he talks about the importance of moving to an expeditious resolution of this case. Judge McGlynn clearly sees that the key now is for the Second Amendment community either to win fast or to lose fast, but whatever happens, speed counts, because it's all about getting to the Supreme Court as fast as possible on these quote-unquote assault weapon cases, these assault weapon ban cases. Here's what Judge McGlynn writes, and I think it's telling as to where his mind is at. He writes, it may also create, meaning granted this preliminary injunction, another reason why he denies this preliminary injunction, because he thinks it will slow down the litigation and waste time, and he thinks it's all about moving with speed. He writes, granted this injunction it may also create further delays in this litigation when the constitutional rights of its citizens demand an expeditious resolution on the merits. You hear what I just said? Expeditious resolution on the merits. What he is saying is what I've been talking about recently, which is that the Supreme Court wants a final judgment on the merits of these issues. They don't want to hear a case on a preliminary injunction basis. They don't want to hear a case on an interlocutory appeal basis, which means in the middle of a case before the case is over, i.e., the entry of a final judgment that says someone has won, someone has lost, and here's the basis for the victory or the loss. And that is exactly what Judge McGlynn is indicating here, that the key now is to move with speed to get an expeditious resolution on the merits, which means a final judgment, so it can go back up on appeal and ultimately get to the Supreme Court, because these back and forths on the injunctions, the preliminary injunctions, it turns out are doing right now nothing but slowing down a final judgment. So going forward, my general advice to the Second Amendment community, if you're litigating these assault weapon type cases, is simply to skip over injunctive relief. Don't bother with it as a general matter. Just try to lose in these terrible blue state courts as fast as possible. Try to win, of course, do what you need to do, but do nothing that will slow these cases down, because the key is that the U.S. Supreme Court is going to have to step into the breach, and they're going to have to issue these rulings, and the faster you get your cases to the U.S. Supreme Court, the better it was for America, because you're simply not going to win in these moronic blue state courts in places like, as a general matter, in places like New York, Massachusetts, Illinois, California, when it comes to these quote-unquote assault weapon cases, at least, black gun cases, AR-15 cases, whatever you want to call them. It's just pretty clear that the intransigence of these terrible judges that control these parts of the country, you're just not going to get over them. They're just not going to do their jobs as inferior courts and follow the Supreme Court precedent. They're going to come up with excuse after excuse to not do their jobs. So the key is to lose fast so you get the U.S. Supreme Court as fast as possible. And then we'll get this cleaned up once and for all, because I have very little doubt that a case before the U.S. Supreme Court on an AR-15 ban or a magazine ban will come out in favor of the Second Amendment, and these laws will be struck down once and for all. But you got to get to the Supreme Court as fast as possible. And again, as a reminder, you're never going to get a red state court to strike down a quote-unquote assault weapon ban, because you're never going to have a type of an AR-15 or magazine ban in Texas or Florida or these places that will give rise to a court ruling knocking them out, because you're never going to have the law in the first place to challenge, which is great, except, of course, it means you have to muck around in these blue state jurisdictions, the Illinois of the world, the Marylands of the world, the New Yorks of the world, the Massachusetts of the world, the Californias of the world, and you get my point. And you're in front of a bunch of terrible anti-gun left-wing judges in a lot of these jurisdictions. I don't have to name names because we've talked about them on this channel. And my last point here is I'm happy to say Judge McGlynn clearly is indicating he is going to follow the Supreme Court precedent in the text of the Second Amendment. When you look at his summary before he denies the motions of the Second Amendment plaintiffs and grants the relief requested by the government defendants, this is what he writes. Neither the legislative branch, the executive branch, nor the judicial branch may change the fundamental relationship between citizens and government. Government exists to serve us, not lord over us. Did you hear what I just said? Judge McGlynn writes in his opinion, government exists to serve us, not lord over us. Sounds like rhetoric you might hear from the Four Boxes Diner. Judge McGlynn goes on to say, the Constitution places limits on government's power while guaranteeing freedom and liberty to the people. The Second Amendment guarantees are fundamental and belong to the citizens. The Second Amendment acknowledges a right of the people, not a license to be issued or denied by the government as it sees fit. Judge McGlynn goes on to say, very powerful language here, this court, that's Judge McGlynn, this court will endeavor to faithfully apply Heller, McDonald, and Bruin, and to harmonize, ding, 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 ding. He's indicating there's a problem. And to harmonize the Seventh Circuit opinions of Friedman versus City of Highland Park and Bevis with them. He's basically signaling that he's going to try to make these ridiculously stupid, unconstitutionally inconsistent rulings of Bevis and City of Highland Park Friedman cases. He's going to try to harmonize these nut job decisions with the Supreme Court binding precedents of Heller, McDonald, and Bruin. That's a hint that he thinks there's a disconnect between the Court of Appeals for the Seventh Circuit's decisions on these cases involving the Second Amendment and the actual Supreme Court's decisions, which is clearly the case. And I'm happy to see Judge McGlynn is flagging the sorts of things that we flag here on this Four Boxes Diner Second Amendment channel. And to conclude, Judge McGlynn writes, any entreaties to ignore, erode, or infringe the constitutional rights of the people will not gain traction in this court, period, full stop. It is clear that Judge McGlynn disagrees with the U.S. Court of Appeals decision for the Seventh Circuit to essentially uphold all of these laws, these gun control laws in Illinois. He is going to do his best to resolve this case as fast as possible so it can go back up to the appellate court and ultimately to the Supreme Court. And he specifically is indicating that the U.S. Court of Appeals decisions in Friedman and in Bevis are inconsistent with the Supreme Court, and he's doing it politely by using the words, the verb, to harmonize. To harmonize. He's going to try to harmonize faithfully all these precedents, indicating that there's a problem with doing so, but he will try to do something that has been tasked to him, even though it is likely impossible because the Seventh Circuit simply ignored the Supreme Court precedent that's binding on all federal courts. Nevertheless, that is where we are. So, bottom line is Stephen McGlynn, the Judge Stephen McGlynn, the U.S. District Court for the Southern District of Illinois, clearly intends to get a resolution of this case fast, which is in the best interest of the Second Amendment community, because it's getting pretty clear to me that we're really not going to have any of our rights protected when it comes to these bans on AR-15s, or magazines that hold more than 10 rounds until we get a decision by the U.S. Supreme Court, because these blue state judges are simply not going to give us the rights that we're entitled to under the Second Amendment. They simply do not care, and they're going to look for every excuse and pretext to stop that from occurring on their watch. It's pretty clear where we're at. Unfortunately, we have these unconstitutional judges refusing to follow and faithfully apply the U.S. Constitution as I see it. But again, only time will tell. The history of the future is yet to be written, so we'll see what happens. All right, folks, hope you learned a little bit something here today at the Four Boxes Diner. We'll keep you abreast of this case and more. And don't forget to follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.